Imagine you're walking into court. You've spent the whole mint end prepping.
Oh, yeah, we've all been there.
Right. You step up to the podium, you cite this absolute slam dunk precedent to the judge to win your motion, and the judge just peers down from the bench and says, "Counsel, this case does not exist."
Truly a nightmare scenario.
And the crazy thing is, it isn't a hypothetical law school nightmare anymore. That is a reality that has literally ended legal careers over the last 2 years.
It really has, yeah.
And it is exactly why we're doing this deep dive today. We've got a massive stack of sources on the table for this one. We're looking at the latest 2025 Bar Association ethics opinions from New York, California, Florida, Washington, plus tech spec sheets, pricing guides from Thomson Reuters, LexisNexis, Clio, and a bunch of in-depth industry research on enterprise legal software.
I mean, it's a mountain of reading, but the mandate from all of it is super clear.
Right. And our mission today is to distill all of that specifically for you, the listener. So if you're a solo practitioner or maybe a partner at a small firm with, 2 to 10 attorneys, you're probably looking to leverage AI so you can punch above your weight class.
Yeah, compete with the massive firm.
Exactly. But you absolutely cannot risk your license to practice law in the process. So we are going to cut through the Silicon Valley tech hype and look at the actual practical realities of 5 specific legal AI tools.
Which are Harvey AI, Clio Duo, Lexis Plus AI, Westlaw Precision, and CoCounsel.
Yep. We're going to break down what they physically replace in your daily workflow, what they actually cost, and crucially, their real hallucination risks.
Which means, honestly, we have to start by looking at the factual landscape of legal ethics. Before we even touch the software, we need to understand the guardrails.
Yeah, the ethics elephant in the room.
Right, because a calm, measured look at the guidance from the ABA, alongside those state opinions you just mentioned from Washington, Florida, New York, California, it reveals a completely unified theme across the board.
Which is?
That your core duties as a lawyer remain entirely unchanged by this technology.
Okay, let's unpack this. Because, the rules of professional conduct didn't magically rewrite themselves just because somebody released ChatGPT. The standards are the standards.
Precisely. So let's look at how the existing rules apply. Under RPC 1.1, the duty of competence, you must understand the technology you're choosing to use. You can't just plead ignorance if it goes wrong.
Right, the I don't get computers defense doesn't fly.
Exactly. And then under RPC 1.6, confidentiality, you cannot just dump sensitive client data into public open source AI models.
Like just typing it into a standard web browser prompt?
Yeah, you can't do that because that data might be used to train the model, which completely destroys attorney-client privilege.
Wow, yeah.
And finally, under RPC 3.3, candor to the tribunal, you are strictly, uncompromisingly liable for every single word and citation you file.
And we have seen the disastrous, very public consequences of ignoring that rule. I mean, the wild part about the infamous Mata v. Aviaka case in New York wasn't just that the lawyers used a basic AI model to write a brief full of completely fabricated cases.
It gets worse.
It gets so much worse because when the opposing counsel couldn't find the cases, the lawyer went back to the AI and literally asked it, "Are these cases real?"
Unbelievable.
And the AI basically said, "Yep, absolutely real." And he submitted a screenshot of that conversation to the judge.
Yeah, a screenshot of a chatbot as proof of case law.
Or look at the recent disciplinary cases in Colorado. Or Coles v. Ellison in Minnesota, where an expert declaration contains citations to entirely non-existent academic articles. It's terrifying.
It really is.
So how on earth does a solo attorney who is already drowning in case files and trying to hit billable targets balance that crushing pressure with this strict requirement of human-in-the-loop verification?
Well, what's fascinating here is that none of these ethics opinions actually ban AI.
Oh.
Right. They aren't telling you to go back to typewriters. They demand supervision. Under RPC 5.1 and 5.3, AI is treated legally and ethically, much like a non-lawyer assistant.
Okay, so like a paralegal.
Exactly. It's treated like a brand new paralegal, or maybe a first-year associate. Think about the reality of your practice. You wouldn't take a complex summary judgment brief written by a paralegal on their very first day, blindly sign your name to it, and file it without reading a single word. Right?
Can you be insane to do that?
Exactly. The exact same standard applies to artificial intelligence. The tool does the heavy lifting of generating the draft, but you apply the professional judgment and the verification. You are the final filter.
Okay, so if the bar associations are explicitly telling us we have to treat AI like a junior paralegal, then the smartest place for a solo lawyer to start delegating isn't necessarily writing a high-stakes closing argument.
No, definitely not.
It's offloading the back office drudgery. Because for a lot of the solos and small firm partners listening right now, the biggest drain on their time isn't legal research, it's the sheer suffocating weight of administrative tasks.
Which is so true.
And that leads us directly to the first tool on our list, Clio Duo, which is actually evolving into their Manage AI suite.
That is the perfect place to start, because Clio Duo is built directly into Clio's practice management software. When we talk about what this tool physically replaces in a law firm, we are talking about the administrative friction that just eats up all of your non-billable hours.
All that time spent not making money.
Right. So if you upload a massive stack of court documents, it reads through them, extracts the critical deadlines, and automatically populates calendar events for you.
Wow.
Yeah, and it can generate draft invoices by pulling from your uploaded receipts and time logs. It can even refine the tone of your late-night client communications or route bills for internal approval.
So if we go back to our analogy, it's essentially a highly organized administrative assistant who never sleeps, who lives in your computer, and keeps the firm's calendar perfectly compliant so you can actually focus on legal strategy instead of data entry.
That's a great way to put it, yeah.
So what is the financial hit for this?
Well, it is built directly into Clio Manage as an add-on, so the cost is highly integrated into your existing software overhead, which keeps it very accessible. And the key factor here, the thing that should help everyone sleep at night, is that the hallucination risk is exceptionally low.
Wait, why is that? Because we just spent 5 minutes talking about AI making things up out of thin air just to please you. Why is Clio suddenly immune to that?
Because of how the technology operates under the hood.
Yeah.
Manage AI operates strictly within your firm's siloed data.
Okay, siloed.
Right? It is not going out and searching the open internet for answers. And crucially, it does not use your client data to train open large language models. It's an enclosed system. To use an analogy, it's like giving an assistant access to one specific locked filing cabinet and telling them they can only give you answers based on what is currently in those specific folders.
Ah, got it.
It's looking at your specific PDF court document to find a date, not hallucinating a date from the ether.
Okay, that distinction, the locked filing cabinet versus the open internet, is massive. So if Clio is the administrative backbone, what happens when a firm needs to process massive amounts of complex litigation or transactional data?
It's scaling up.
Yeah, say you are doing M&A work or you're facing a huge document dump in a civil suit. This brings us to the heavyweight challenger of our stack, Harvey AI.
Harvey AI is undeniably the most talked about tool in the enterprise legal space right now. When we look at what it replaces, it is aimed squarely at eliminating hours, if not days, of manual due diligence, contract analysis, and preliminary legal research.
So it's a massive time saver.
Huge. It has a feature called the Vault, which allows it to analyze bulk documents simultaneously.
Oh, wow.
So you can have it read through hundreds of pages of vendor contracts, extract very specific indemnification clauses from all of them, and summarize the minute differences across that massive stack in minutes.
But the pricing on Harvey is custom or enterprise level. Historically, this has been aimed squarely at big law, like the massive international firms. So why should a solo practitioner or a 10-person firm listening to this even care about Harvey?
Because it serves as the aspirational benchmark for what is possible. And frankly, because they're beginning to offer tiers and alliances that smaller firms are paying very close attention to.
Okay, so it's trickling down.
Yes, but you do have to be careful with Harvey. The hallucination risk with a generative tool like this can be moderately high if you're using it blindly to generate case law out of nowhere.
Because at its core, a standard large language model is just a prediction engine. It's, predicting the next logical word in a sentence based on patterns. It's not actually querying a factual database.
Exactly. However, there's been a massive industry-shifting development recently. LexisNexis and Harvey announced a strategic alliance to integrate what they call the protege service.
A protege service. Okay.
Right. This grounds Harvey's generative outputs directly in LexisNexis U.S. case law and Shepard citations.
Explain the mechanics of that. What does that actually mean for the solo lawyer who is terrified of hallucinations?
It mitigates the risk tremendously through a process called retrieval augmented generation, or RAG.
Rad.
Yes. Instead of the AI just predicting the next word based on everything it read on the public internet, It is mathematically forced to run a search within the proprietary Lexis database.
Oh, that's smart.
It pulls the actual verified text of a real case, and it is restricted to only summarizing those specific words. You are shrinking the AI's universe from everything ever written to only verified legal facts.
Okay, yeah.
If we connect this to the bigger picture, Harvey and LexisNexis are co-developing automated workflows for massive undertakings, like drafting motions to dismiss and motions for summary judgment.
Which take forever.
Exactly. Think about the implications of that. Automating a motion to dismiss workflow gives a 5-person firm the sheer analytical bandwidth of a 50-person AmLaw 200 firm. They can process the same amount of data in the same amount of time.
That's incredible.
Provided, of course, that the human attorneys actually review the output.
Right, obviously. But that is the ultimate equalizer. It levels the playing field completely. But, as you said, Harvey is a custom enterprise beast. For the solo and small firm litigators listening who don't have time to negotiate custom enterprise contracts, they need out-of-the-box trusted research tools with transparent month-to-month pricing.
Exactly.
So how do the legacy platforms stack up in this new era?
They stack up incredibly well, specifically because they own the underlying data. They own the libraries.
Yeah.
Let's look at CoCounsel by Thomson Reuters.
Okay.
It acts as a specialized legal assistant for document review, contract analysis, and generating complex compliance checklists. It replaces the manual, agonizing hours spent verifying jurisdictional nuances across different state regulations.
And what's the cost there?
The transparent cost for CoCounsel starts around $225 to $279 per user per month.
Okay, but wait. Lexis plus AI costs between $80 and $135 a month. CoCounsel is over $200. As a solo on a tight budget, my immediate thought, and I know a lot of people listening are thinking this, is ChatGPT is $20 a month.
Right, the $20 temptation.
Yeah. Why shouldn't I just use the cheap open model, save my firm hundreds of dollars, and just rigorously check the citations myself?
Because of the foundational difference between the tools. Think of standard ChatGPT like a brilliant, eager-to-please intern who desperately wants a full-time job.
Okay.
They are terrified of saying, I don't know. So if you ask them for a case supporting your super niche argument, they will invent a perfectly formatted, completely fake case just to make you happy.
Just to give you an answer.
Exactly. Now, think of Lexis plus AI, Westlaw Precision, and CoCounsel like a strict veteran law librarian who's only physically allowed to hand you books that are actually sitting on the shelf in front of them.
I love that analogy.
Yeah, the hallucination risk on these legacy platforms is incredibly low because they are closed universe systems. They're pulling exclusively from proprietary, verified legal databases rather than scraping Reddit and Wikipedia.
Here's where it gets really interesting to me. When you use Lexis plus AI or Westlaw Precision, which are, the direct evolutions of the platforms we all lived on in law school, these tools do not replace your judgment as a lawyer.
No, not at all.
They replace the search function. Instead of you sitting at your desk for 3 hours running complex Boolean searches trying to find the raw materials to build an argument, the AI presents the raw materials to you instantly.
Right.
And then you spend your precious time actually building the argument.
That is the crucial distinction you have to internalize.
Yeah.
You're moving your brain from a search and gather role to a synthesize and apply role. It elevates what you do.
But I do want to channel the very real anxiety of the solo practitioner right now. Surveys of the legal tech industry show that 75% of attorneys cite AI hallucinations as their primary fear preventing adoption.
It's the biggest hurdle, yeah.
So if I am using these tools, what is the actual malpractice risk? And more importantly, how do I, as a solo lawyer, verify this output without spending the exact amount of time the AI was supposed to save me in the first place?
Which defeats the purpose.
Exactly. Because if an AI drafts a brief and I have to go read every single 50-page case it cites from scratch just to make sure I don't lose my license, I haven't saved any time, I've just added a layer of software.
The verification workflow is exactly where you mitigate your malpractice risk, and it requires a precise, disciplined methodology. The goal isn't to expect the AI to be infallible.
Right.
The goal is to implement it responsibly into your practice. When you use a tool with Shepard Citations integration like you find in Lexis plus AI or that new Harvey alliance, you must click through the links to the primary sources.
Okay, so you still have to click through.
Yes. Now, to your point, you do not have to read the entire 50-page opinion from scratch, but you must verify 3 things.
Whoa.
1, you verify that the case actually exists. 2, you verify that the core holding is accurately represented by the AI. And 3, you verify that the specific quote it pulled is real and in context.
Okay, that seems doable.
Very doable. The AI flags the relevant paragraph for you instantly, so your job is just to verify its application. It takes minutes, not hours.
Okay, so what does this all mean for the business side of a law firm? Because this leads us directly into the billing ethics dilemma.
Oh, yes.
This is the sharp, practical pushback I hear from partners all the time. Let's walk through a scenario.
Sure.
Let's say I use an AI tool, and it drafts a solid 80% ready summary judgment motion in 20 minutes. Historically, researching and drafting that motion from scratch would have taken me 10 billable hours.
Well, hey,
How do I legally bill my client? Do I bill them for 20 minutes? Because if I'm cutting a 10-hour bill down to 20 minutes, I'm going out of business next month.
this is a major friction point, and this is where we have to look closely at current guidance, like the WSBA Advisory Opinion 2025-05 regarding RPC 1.5, which governs reasonable fees.
And what does it say?
The guidance is unequivocal. You cannot bill a client for the time saved by AI.
Wow.
If you spend exactly 2 hours prompting the AI, reviewing the output, checking the citations, and refining the draft to perfection, you can only bill for those 2 actual hours worked. You cannot ethically bill for the 10 hours it would have taken you manually.
Wait, so the lawyer who invests in technology is financially punished for becoming more efficient?
Under a strict traditional billable hour model, yes, absolutely.
That's wild.
It is, which is why this technological shift requires firms to fundamentally rethink their business models.
Mm-hmm.
You have to strongly consider moving away from the billable hour toward alternative value-based fee arrangements or flat fees.
Oh, I see.
Let's look at the math. If that summary judgment motion provides $5,000 worth of strategic value to the client's case, you charge a flat fee of $5,000 for that milestone. You aren't billing for the minutes the clock was ticking, you're billing for the outcome.
To the value.
Exactly, for your expertise and for your judgment in utilizing the technology to achieve a win.
That is a massive paradigm shift. It forces the solo attorney to stop acting like a time tracker and start acting like a business owner selling value.
Exactly.
Yeah.
And it finally aligns your financial incentives with the client's ultimate desire, which is efficiency and actual results.
All right, let's bring this all together for the ultimate pragmatic question. For the solo attorney listening to this right now, maybe driving to court or sitting at their desk looking at a mountain of files who is operating on a very strict $200 a month technology budget.
Okay.
They can't buy everything we just talked about. What is the exact play? What do they prioritize today?
This raises an important question about resource allocation and brutal honesty about your own workflow. With a strict $200 a month budget, you immediately skip Harvey AI, which requires custom enterprise pricing.
Right, too expensive.
You also have to skip CoCounsel, which exceeds your budget at $225 to $279 a month. Instead, the solo attorney needs to look at their biggest daily pain point and choose between two distinct paths.
Okay, split those paths out for me.
Path 1. If your days are being eaten alive by administrative bloat, if you're spending your evenings sorting inbox emails, manually tracking billing, and inputting calendar deadlines, you prioritize Clio Duo or Manage AI.
To get your time back.
Yes. You need to rescue those lost non-billable hours just to survive. Path 2, on the other hand, if you have a handle on your admin, but your practice is heavily litigation-based, and you're constantly drowning in complex case law research,
Then what?
you prioritize Lexis plus AI. That runs about $80 to $135 a month. You get closed universe, hallucination-resistant research that fits perfectly within your budget, and you never have to worry about citing a fake case.
And what if you're a listener at a 10-person firm? You aren't the one making the solo budget decisions. You have to convince a skeptical managing partner to adopt this.
Then you pitch what I call the capital investment of time.
The capital investment of time. I like that.
You don't pitch the tech, you pitch the ROI. You go to managing partner and say, give me 10 non-billable hours this month to configure these closed system AI tools, set up our firm templates, and build our automated workflows. It will cost us 10 hours now.
Right.
But in exchange for that initial investment, I will save this firm 70 billable hours every single month thereafter. You frame it entirely around the return on investment and the ability to take on more clients without hiring more associates.
I love that. A capital investment of time. It frames it as an asset, not an expense. So as we wrap up this deep dive, I want to leave you with a lingering thought. We opened today by talking about the nightmare of fake citations. the muddy waters of early AI.
The Madaviavianka nightmare.
Exactly. But let's assume the industry clears the mud. Let's assume the LexisNexis integrations and the closed universe systems perfect the citation process, which they are rapidly doing.
They are, yeah.
If AI effectively eliminates the advantage of brute force associate labor, if it allows a solo attorney to instantly generate the same pristine research, the same massive document review as an AmLaw 200 firm, what becomes the true differentiating value of a human lawyer in the coming decade?
It forces us to look in the mirror and ask, was our value ever really just in data processing and Boolean searches, or is it in something much deeper?
Exactly. When the legal research is instant and perfect for everyone, your value is no longer in finding the case. Your value is purely in your judgment, your strategic empathy, your ability to read a judge, and the deep trust you build in your client relationship.
That's profound.
The machine can find the law perfectly, but it cannot sit across a conference table from a terrified client facing a life-altering lawsuit and tell them they're going to be okay. And maybe, by handing the search and gather drudgery over to the AI, we finally get to focus on what actually matters being human.